Welcome again to Cross Continent Law. Today we're going to be continuing. This is a site, as I said before, where we break down legal principles into chewable, digestible bits for your consumption. Today we're going to be continuing with the capacity to enter into an enforceable contract. That is a contract that the law courts will enforce. Because as we said the last time we were discussing, that it's not every contract that the law courts will want to enforce. And we're beginning today with looking at certain classes of people that the law have granted only a partial or qualified capacity to enter into a contract with. Today we're dealing with minors, and we're going to be looking at cases that are from the common law divide, especially the UK, India, or any of the other common law jurisdictions. We are not doing this because there are no cases from the civilian aspect, but we're doing this more or less as an illustration of what we're saying, that minors do have some capacity to enter into a contract, but it's partial and not total. What that means is that when you go to enter into a contract with a minor, you have to be extremely careful. Make sure that the kind of contract that you're going to be doing with the minor is the sort that the courts will enforce for you. Otherwise, you have actually entered into an unenforceable contract, and you open your hands, your tighted fist, and you find out that there is nothing in it but air. So we're going to be looking at some of these cases now. So the first case we're looking at is Nash and a man, where an undergraduate ordered clothes from a Savile Row tailor in London, and when the London tailor sought to enforce that contract, the court said no, that this is a minor, and that you have to prove that the minor, that what you supplied, the contract you did with the minor is for necessaries, which means, of course, that necessaries are one of the few instances that the courts admits that a minor can contract. So, and we know that necessaries are the things that are necessary for the day-to-day living of a human being. So, but again, it might depend on the state of the status of the minor. If it's probably a minor from a very wealthy family, some of what might be necessary for him may not be necessary for some other persons. So now, in this case, this undergraduate ordered clothes from the Savile Row tailor, and this tailor wanted to enforce this contract, but it could not be enforced because the tailor could not convince the court that the contract was for necessaries. Yes, clothes can come as necessaries, but at that stage, unless it's something to do with essential living like food or water, or maybe things like diapers, if it's a very young infant that still wets the bed, you have to prove to the court that what you've supplied to this minor that you seek him to pay you for are necessaries. In this case, on this occasion, the tailor was unable to prove this, and the court refused to enforce the contract against the minor. Again, we have another case there, Imperial Loan against Stone. Again, this was a loan that was granted to a minor, and which the company could not enforce against him, basically because it's a minor. So, and of course, again, you see that this loan is not a necessary. It's not something you can expect the courts to enforce against a minor. Another case is Arun and Prakash. Arun Prakash versus Beach Hotel, where hotel expenses run up by a minor, by a 16-year-old Arun in this case. The court said they could not enforce it. What it means is that, practically speaking, when you enter into a contract that you can see the minor, your best bet is to at least ask them, what is your age? So that from there you can begin to make some mental calculations whether this contract is a contract you can, for instance, enforce subsequently. Whether it's a contract you say, no, you pay me before we get into this contract, otherwise, no deal. So you need to be very aware of that. So in this case, of course, the expenses could not be enforced against Arun because Arun is 16-year-old, under the age of 18. Another case is Chappell and Cooper In this case, however, the court accepted that these were necessary and it was enforced against the minor. Chapel and Cooper was where a female widow was able to get run-up expenses in a contract so that she could bury her husband. So the funeral expenses were held by the court to be necessary and therefore enforceable against the minor. Another case we want to look at is Ryder and Wombell. It's a contract for the supply of precious jewelry, crystals and diamonds and rubies, and the court held that this again did not constitute necessaries, and it was not enforceable against the minor as it were. And of course, from what you find out from these cases is that it is the duty of you that wants to enforce the contract to prove that what you've supplied or that the subject of the contract are necessaries. It's not for the minor to prove that, because don't forget that a contract with a minor is merely voidable. It's not void ab initio. In this sense, it means that if you enter into a contract with a minor, it's enforceable at the instance of the minor, but not enforceable at your instance, which means that if you want to enforce it as an adult, the court leans against you. The onus is upon you to prove that the minor contracted with you for necessaries, and that those necessaries were goods that the minor needed at that time. They don't have sufficient the sufficiency of those goods, So you have to, and that's you find that also in Nash and Iman. So, saying simply, to sum what we've been saying is that minors, that is young children, have only but a partial capacity, a qualified capacity to enter into a contract. They don't have a full-blown capacity like adults to enter into any contract they wish. So if you do that with them, you're running the risk that the contract may not be enforced against the minor. And the cases we've mentioned to you, you can go back again and listen to them and look at them also at your spare time. You find that what they are signifying is that, what they are illustrating rather, is that if you enter into a contract with a minor other than for necessaries, such contracts may not be enforced. I'm sure you'll find in the civil law divide in some French cases or German cases, you will find cases also that are illustrating these same principles. And then I'll be ready, willing to take your questions or your views or comments on what we've looked at today. That is, the capacity of minors to enter into an enforceable contract. Thank you again for stopping by on this platform, Cross Continent Law. Bye-bye till the next time again we meet again. The next discussion, we're going to be looking at the capacity or the qualified capacity of illiterates to enter into an enforceable contract. So don't forget that what we're discussing are the segments or classes of citizens in a society that the courts protect, and who are therefore not expected that you go into a contract with them because they have some disability or the other, which means that you're likely to you have a power differential in your favor against them. So the courts come to defend them. One of them are minors. Like I said in the last discussion, if you decide to contract with a 4-year-old or a 5-year-old, and I use the examples of Abdul somewhere in the Middle East or Clarice somewhere in North America, then you have to be sure, make certain that the contract, the object of the contract, what you're contracting on, should be necessary. Otherwise, it's going to be a difficult task for you to enforce such contracts against the minors. So thank you again. Bye-bye.